Hi, everybody. Thank you for joining us today for our newest edition of our Building a Better Business webinar series by the Better Business Bureau. Today, we are joined by Diane Mokriski from CBIA. She is Human Resource Counsel, and she's going to be covering a topic that I think a lot of our business owners at BBB have questions about. So Connecticut's new marijuana law, what does that mean for your business, your employees? How do you hire new employees? There are a ton of questions around this sometimes odd topic, I guess. So that's why we have Diane here today to help explain to our accredited businesses, and if you're a part of CBIA as well, how to keep your business moving and how this law affects your small local business. So thanks for joining us today, Diane, and I'm going to hand things over to you.
Okay. Thanks very much, Luke. So yeah, I am an attorney here at CBIA. And so my job is to focus on state and federal employment laws and advise business owners and HR professionals on how to comply with those laws. And so you all are here because you've heard that there is a new Connecticut law that legalizes recreational marijuana. And so we're going to talk about how that impacts business owners. And so I'll kind of give you a bit of a spoiler, although there's been a lot of talk about this law in the news. I think that that is primarily because it is now legal to possess and use marijuana in the state of Connecticut. But I can tell you that if you're concerned, if you have a big concern about how this is going to impact your business and whether you now have to allow people to be high at work, you don't have to worry about that. The law itself and the way it pertains to businesses, it actually has significant protections for Connecticut businesses so that they, for that very reason, so they don't have to worry about having people at work that are using marijuana and having to allow that. So I just kind of want to throw that out there in the beginning so that everyone knows you don't actually have to worry about that. So one of the first things, I've split this up into 4 steps. And the first step that I really want to focus on is current law, because although it is now legal to possess and use marijuana if you're a Connecticut resident, the law that pertains to employers and how employers can react to their employees using cannabis, those employment provisions actually don't take effect for another year. And so on July 1st, 2022, those you can call them restrictions, although they're really not even restrictions. They're kind of like specific provisions that pertain to the employment context, and those go into effect next year. And so it's important to understand now what's the law now so I can follow the law for the next year and for right now. And so there are really 3 main parts to the law having to do with drugs and alcohol in the workplace. And it has to do with what employers can do, how it pertains to restricting drug use at work. And so the first thing that's important to know is that employers may prohibit the use of intoxicating substances during work hours. And so that means alcohol, marijuana, and other drugs. So that's obvious, right? You do not have to allow your employees to use illegal substances, and you don't have to allow them to be drunk, even though alcohol is legal, and you don't have to let them use marijuana, even though marijuana is legal. Okay, so that's the first thing to know. You can have that rule. The second thing is that you have that rule, and it is permissible for you as an employer to discipline your employees for being under the influence during work hours. And that's a qualification that's kind of important to keep in mind, because we're talking about what's your employee conduct at work. And so what the law says currently is that you can discipline your employees for being under the influence at work, okay? And currently you can require drug testing, and there are basically 3 different kinds of drug testing. And one kind of drug test is called pre-employment drug testing. And so that's part of the application procedure. And so that's the type of thing where you wouldn't want to do that on a case-by-case basis. That will open you up to a discrimination claim. And so you wouldn't want to say, for example, this lady looks kind of shady. I'm gonna do a pre-employment drug test with her. You want to decide at the outset, okay, we're going to do pre-employment drug testing or we're not. And if you decide that you are going to, then that is permissible. And we'll talk about what the rules are for those. The second kind of drug testing is when an employer has reasonable suspicion that an employee is under the influence at work. And so we'll talk about that in more detail. And then the third kind of drug testing is called random testing. And that has strict rules that you cannot just randomly test any of your employees at any time. That's considered a violation of privacy. And so there are rules, only certain types of employees can be randomly tested. And so we'll talk about that in the next slides. So the first kind of testing that we talked about, and again, this is current law, although you'll see, when we get to the part about the new law, you'll see that there are not a lot of super significant changes. So if you understand current law, you'll understand a lot of what the law is when it takes effect next year. So the first kind of testing is pre-employment testing. So if you decide to do that across the board, there are some rules. And so the first one is that the prospective employee has to be informed in writing at the time of application. So when he or she gets his application, you let them know, just so you know, drug testing is part of this application process. And so if it's a urinalysis test, the law provides that if that test comes back positive, you have to confirm it with a second test. Now you'll see that first part of this sentence is that if it's a urinalysis test. And one kind of interesting part of Connecticut law having to do with drug testing is that the only type of drug testing that is regulated by Connecticut law is urinalysis testing. And so that creates kind of this unknown area where if an employer wants to conduct testing of saliva or hair or blood, these rules that I'm about to talk to you about don't really apply. Connecticut law doesn't regulate that. And so for all of these, whether it's pre-employment or random or reasonable basis testing, it all has to do with urinalysis testing. And so the law says if you're going to use a urinalysis test to make a decision about someone's employment, and if that test comes back positive, you have to do it again to confirm the positive test. The prospective employee has to be given a copy of the positive result. And then you have to give that test before the person starts. That's important because there are different rules, having different drug testing rules depending on whether the person is a prospective employee as opposed to a current employee. And so what you don't want to do is have the person start on their first day and then say, oh, your drug test, your pre-employment drug test is scheduled for today or for tomorrow. By then it's too late. He's already an employee and there's no reason to test him. So you have to make sure that they haven't started the job when they take the test. So the second kind of testing is reasonable suspicion testing. And so let's say you have a current employee and you want to give that employee a drug test because you really think that maybe they're under the influence of something at work. Again, this is only going to be urinalysis testing. But if you have reasonable suspicion that an employee is currently, like at the time that you want to give the test, you have reasonable suspicion that that employee is under the influence of drugs and alcohol, and the influence, the way that they're influenced by the drugs or alcohol adversely affects their job performance, then you can conduct reasonable suspicion testing. So obviously one of the most common questions that comes up is, well, what's reasonable suspicion testing, right? And the Labor Department in Connecticut has made efforts to make that more clear. It is not part of the law, so there is nothing black and white that you can definitely, there's no list of 3 things that if you definitely find these 3 things, you definitely have reasonable suspicion. But the Labor Department has published a list of potential symptoms that you might think shows you that you have reasonable suspicion that someone's under the influence. And they're self-explanatory and I think obvious. So for example, bloodshot eyes is one factor, slurred speech, the smell of alcohol, the smell of marijuana, a change in a person's judgment, a reaction time, also carelessness, or behavior that impacts their ability to, for example, use machinery safely. If you see changes in their conduct that are indicative to you that they're under the influence of drugs or alcohol, then that will give you grounds to conduct reasonable suspicion testing. And then finally, the third kind of drug testing is the random testing. And this is the kind of testing that I would say is the most strict. It's true that reasonable suspicion testing is also kind of strict because you need to be able to document those factors that give you grounds to do that reasonable suspicion testing. But the random testing actually is governed by law. There are only a few scenarios that will allow you to do the random testing. Again, this is urinalysis testing only. And so you can conduct random testing of your employees if the test is authorized by federal law. So when we're talking about drug testing in Connecticut and when we're talking about the ways in which an employer can discipline employees for using drugs, we're mostly talking about Connecticut law. But there are some positions that will be governed by federal law, like commercial driver's license drivers. And so if the position is governed by federal law and it provides for drug testing, then you can do the random test. The second scenario where you can conduct a random test is if the employee works in a high risk or a safety sensitive position. And so that is governed by Connecticut law. And what you have to do there, if you're an employer, is you have to correspond with the Connecticut Labor Department. You actually write to the Labor Department and you tell them which positions in your company you believe are high risk or safety sensitive. You ask the Labor Department to formally designate in writing that those positions are high risk or safety sensitive. And if you get that designation, which by the way can take up to 90 days, but if you get that designation, then you can conduct random testing on the employees in that position. And so the Labor Department has issued a list of positions that they've given this designation to in the past, but it's important to realize that the designation of safety sensitive belongs to the individual employer. So for example, in the past, the Connecticut Labor Department has designated the position of chemist, the position of crane operator, explosives operator, which seems obvious. Those are examples of positions that have been designated as safety sensitive in the past. If you have any of those positions at your company, it's likely that that designation will be granted to you as well, but it's not definite. So you have to write to the Labor Department and get that designation that will belong to your company specifically. And if you get that, you can conduct random testing. And so the basis for that is obvious, I think. If the way that a position becomes high risk or safety sensitive is if that position poses a risk, a life-threatening risk to the employee or others, and if it also involves the employee's use of judgment. And so the Labor Department will evaluate that, and if they feel that those criteria are met, you'll get your designation, and then you can conduct your random testing. And then the third way you can do random testing is if you have an EAP, and if the employee voluntarily participates in that and random testing is part of that, then that'll be permissible. All right, and so those are the basic rules about current law for recreational marijuana. I just want to make sure everyone understands there's a bit of a carve out for medical marijuana currently. And so Connecticut law provides that disciplinary decisions and refusals to hire applicants cannot be based on the employee's status as a medical marijuana card holder. And I just want to distinguish that from this part of the law, which says decisions can be made based on the employee's actual use of marijuana or based on the employee being under the influence of marijuana during work hours. And so what that means with respect to medical marijuana, let's say you have an applicant and the applicant says to you, hey, just a heads up, I have a medical marijuana card. I hope that's not an issue. Your response to that should be, nope, not an issue, because you cannot refuse to hire someone simply because they have a card and simply because they will have the right to use medical marijuana when appropriate. On the flip side, if an employee has a medical marijuana card, and so then they believe that, or let's say, then they use marijuana, right? And they do it on Monday morning, right before they come to work. And so they're under the influence of medical marijuana at work. That is not allowed. And so simply the fact of them having the card does not give them the right to be under the influence at work. All right, so that is kind of a brief summary of what the current state of the law is right now. And so this step 2 of this process is to figure out whether the new law is even going to apply to you, because there are lots and lots of exemptions. And so after you understand the current law, you move on to step 2 and you figure out, all right, is my company itself exempt? And as I said, there's lots of exempt industries. There are 9. And so I'll just list them. They're mining, utilities, construction, manufacturing, transportation and delivery, educational services, healthcare and social services, justice, public order and safety, and national security and international affairs. And these are based in part on the NAICS codes, the North American Industry Classification System codes. So for example, I think the NAICS code for mining is 21. So the statute that goes into effect next year says, if your company is in the business of mining or your NAICS code is 21, then you're exempt. And that's true of all of the 9 categories. The statute lists the NAICS code, and so you can kind of use that to go by and figure out if you're exempt. So what that means is that if your company falls into one of these 9 exemptions, your entire workforce for your company is exempt from the new law. And so that's really just going to tell you, okay, so next year when this law goes into effect having to do with marijuana use at work, I don't really need to pay attention to that. I just need to know what the current law is. okay? So let's say you're not one of the 9 exempt industries. You still have another step to go through, and that's trying to figure out, even if your company is not exempt, you might have some employees that are exempt. And I just want to make clear that when I say exempt, usually in the employment context, the employment law context, when we talk about exemptions, we're talking about whether someone's exempt from overtime or minimum wage, right? That's not what we're talking about here. When we're saying is the employee exempt, what I mean is the employee exempt from the new recreational marijuana law at work, okay? So there are 13 types of exempt positions. And so I'll list those, and then I'll see if I can help you figure out how to evaluate that. So some of them are obvious, like firefighter, EMT, police and correctional officers, drivers, like CDL drivers, anybody subject to the Department of Transportation, the FAA, the Coast Guard, positions requiring an OSHA certification, positions requiring a Department of Defense or Department of Energy national security clearance, positions funded by a federal grant, those who care for children, medical patients, or vulnerable persons, and employees who work for a nonprofit whose primary purpose is to discourage drug use. And then there are a couple of catch-alls here, which I think the legislators kind of threw in there because they weren't sure if they were forgetting somebody. So 11 and 12 are positions subject to any conflicting federal law. So if there's any federal law out there that governs drug testing, drug use at work, and that federal law conflicts with the new state law, the federal law will govern. And then any position that has the potential to adversely impact the health or safety of employees or members of the public as determined by you. So the theory of this is that this new law is going to restrict in some ways an employer's ability to discipline employees for using marijuana. In reality, I think you'll see by the end of this webinar that that's not actually the case. But the theory is that it starts some new restrictions. And so these exemptions, the purpose of the exemption is to say, if you've got someone who's really in a safety sensitive position, I'll say, for ease, and the employer really feels it's important to not be restricted on how they govern this employee and their use of marijuana use, the employer could make that argument and not have to follow the new law. But like I said, I think what you'll see as we go through these slides, the new law really doesn't restrict employers very much. And you can ask questions about that as we go through, but it's not going to be a huge difference. And then finally, 13 is any employee who works for an exempt employer. We talked about that already. If you're an exempt employer, then all your employees are exempt and you don't have to learn the new requirements of the new law. Okay, so let's say you figured out that, well, let me just touch on one thing before we move on to those exempt positions. You just want to make sure this is clear that, let's say you're not in an exempt industry. So let's say, for example, my company, CBIA, is not exempt. And so this company next year will need to understand the new law. But CBIA, in theory, might employ some people whose individual positions are exempt. So if we have anybody here who needs an OSHA certification, then that person would be exempt. And so this company would only need to apply the new law to the employees who are not exempt from it. Okay, so that's a little bit confusing. You might have to follow current law for some employees, and next year's law for others. That's actually not going to be a huge problem, I don't think, because the two laws are actually very similar and you can kind of encompass them all with a policy. And so we'll talk about that. So the final step is understanding the new law. And I've put this up in really 2 slides, and I've separated them out in terms of what an employer can do beginning July 1st next year and what an employer cannot do. That's the next slide. And it's funny, the reason why I did it this way is because, as I mentioned earlier, the new statute was written in a way that it specifically contains protections for employers so that they don't have to be concerned about having employees at work who are under the influence. And so one thing that's a little bit unusual about this new law is that it specifically contains language saying pretty much, don't worry, you can still do the following things. And so I've listed those here. One of the things that the statute specifically says an employer can still do beginning July 1st next year is an employer can still enforce rules requiring a drug and alcohol-free workplace. Great. That's no different from current law. That will also be the law next year. The statute also says that an employer can prohibit employees from possessing, using, or consuming cannabis while working or while on premises. And so the reason why this is specifically in the statute is because the current law, or maybe it would be easier to describe it as like your current policy, probably says something like, this employer prohibits the use of illegal drugs or alcohol. So that's not going to work anymore starting next year, right? Because you're not going to want your employees, in theory, to use marijuana, and marijuana is not illegal. And so what this, marijuana is not illegal even now, today. And so what this part of the statute is clarifying is that this can apply to cannabis too. So you can have a rule saying you can't use, even though it's legal, same as alcohol, you can have a rule saying you cannot use it while at work. And so the verbs there, you'll notice, are possess, use, and consume. You can have a rule that prohibits all 3 of those. The only exception is that when it comes to medical marijuana, the statute refers to it as palliative cannabis, right? And so the exception there is that employees who have a medical marijuana card may possess their medical marijuana at work. They may not use it though. Okay. The third thing that the statute specifically says you can do still is you can implement a policy that prohibits the possession and use of recreational cannabis. So what you want to do with that policy though is you want to make sure that it's in writing and you have to actually pass it out to everybody. Everybody has to have a copy. And so that'll be kind of one of the main goals after this webinar is that everyone should have a policy in writing. And you'll decide what you want your policy to be. For example, whether you want to do pre-employment testing or not. Once you have that policy and it's in writing and you give it out to everyone, then that's going to be your policy and you can use it and discipline employees in accordance with that policy. Number 4, this is something that also is not a change, but specifically spells out in this new law. Employers can discipline employees based on the employer's reasonable suspicion of the use of cannabis at work or based on the employee's symptoms of drug impairment that impact their performance. And so that should look familiar because that's the standard for reasonable suspicion drug testing, the current standard. And so an employer can now and next year discipline employees based on that reasonable suspicion that the employee is under the influence at work. So you can discipline employees because you have reasonable suspicion that they're drunk or using marijuana or using cocaine. if you have reasonable suspicion of that, and the way that you arrive at that conclusion is that they are showing symptoms at work that impact their ability to do their job, you can react to that in two ways. You can drug test them, and that would be the reasonable suspicion drug test. Or one thing to keep in mind is that, like number 4 says, you can just discipline that employee. You don't have to drug test them in order to discipline them. It's not necessarily a two-step process. So this actually just came up a few days ago. A business owner was expressing to me that he was really concerned because one of his employees, he was quite sure one of his employees was under the influence of something at work. His speech was slurred. He seemed very sleepy. His eyes were bloodshot, and he was making mistakes at work, and he used dangerous machinery. So that employer is not required to drug test the employee first. He could have drug tested that employee because there was enough to give him reasonable suspicion to drug test. But he could have also just disciplined that employee. And so some of the things we talked about was he could terminate the employee. He could transfer the employee to a position that didn't involve the use of a dangerous machine. You could suspend the employee. There are a lot of options. And so it's important to remember the drug testing statute in Connecticut has to do with employee privacy. And so there are rules about when you can invade that privacy by conducting a drug test. So as we discussed, there are rules about when you can do that drug test. But it's important to remember that there's no rule that says you can't do anything with the employee until you drug test. You can go right to the discipline without the drug test if you feel that that's appropriate based on what you've observed. All right, so now we get to number 5 and 6, and the reason why they're in red is because they are arguably new and different from current law. And I say arguably because they're not that different. So number 5 says, you can discipline, this is what the statute says for starting next year. You can discipline employees for cannabis use outside of work if you have a policy that says you're going to do that. And so I don't know how many employers would really enforce this, but what this statute says is that beginning next year, if you have a written policy that says we just have no tolerance for drug use at all, and even though marijuana is legal in Connecticut, you can't ever use it. And so if we discover that you used marijuana, legal recreational marijuana over the weekend, you might be fired. That's what the law says you can do starting next year. Like I said, I'm not sure, to be honest, I'm not sure that that part of the statute is super realistic. And I think that there's a pretty good chance that that might not remain. I think that people are going to object to that, and there may be some modifications to that, some changes next year. But that's what the law says as of now. And the other thing that the law says is that you can drug test current and prospective employees in accordance with a written policy. And I've emphasized this on the next slide too, because this is something that the statute says. I think that it's unintentional, because technically what the statute says is that you can, if you have a policy, a written policy that you give out to all your employees, and the policy says, we're going to do random drug testing of everybody. What this statute says is that starting next year, you can do that as long as you have a policy that says you're going to do that. And I have to say, I really don't think that that's what the legislature intended. I think there have for many years been very strict rules about when you can do drug testing. And so I think the intent of this provision of the statute is that you can do your drug testing if you have a written policy, and it doesn't actually say this, but and if you comply with all the old drug testing rules. So you'll see from the next slide, that's in red again. And I'll get to that and I'll explain again why I think that's significant. So the former slide was talking about what the statute specifically says. It kind of says, don't worry, you can still do all the following things. But there are some things that the statute spells out you cannot do. Some of them are not new. And so the statute says you cannot discharge or discipline an employee based on his use of marijuana outside of work if you don't have a policy, right? That's just kind of the flip side of what we were talking about on the other slide. Number 2, you cannot discharge, discipline, or adversely treat a current or prospective employee based on his history of marijuana use outside of work before employment started. So I think like for most employers that would be kind of obvious, but unless you have a federal contract or you're getting federal funding, that's one exception. But I put in here as an example old Facebook posts because this came up for me when I was in private practice. I represented a company who wanted to hire someone, and they went through his old Facebook posts and were kind of doing some research on this applicant, and they found old photos that he had posted of him smoking marijuana. So at the time, marijuana was illegal. And so one of the issues that came up was, what kind of impact that was going to have on whether they hired this employee. So what this statute says now is that starting next year, if that happens to you as an employer, if you find out that you have an applicant, or if you find out that one of your employees in the past, before they started working for you, used marijuana, you cannot use that as a basis for not hiring them or as a basis for firing them. And that probably is the one significant change to the statute that is specific and that will probably remain. And so, but I just don't think that was a huge problem, but that's what the new statute says. So starting next year, employers cannot do that. And then number 3 talks about what an employer cannot do. It kind of restricts what an employer can do when they drug test an employee, and the only thing that comes up positive is THC. THC is the active ingredient in marijuana. The thing about this provision is that I think you'll see it's really still not very different from current law, but what the statute says is that beginning next year, if you drug test someone and the only thing that comes up positive, even though you drug tested for everything, and it could have come up positive for cocaine or heroin or whatever, the only thing that comes up is THC, then you cannot penalize that person unless you would risk a federal contract or unless you reasonably suspect that the person was using marijuana at work, which is also current law, or the employee showed symptoms of drug impairment at work that impaired performance, that's also current law, or unless the test was given pursuant to a written, disseminated, random drug testing policy. All right, so that's in red because that is what the statute actually says, but that, like in the former slide, I think that is not going to stay, to be honest with you, because if you follow this statute just according to what it actually says, what the statute says is that if you have a policy that's in writing and that you give out, and it says that you as an employer are going to do random drug testing of everybody, and the test comes back, even if the test only comes back positive for THC, you can fire that person. And the law does not say anything about safety sensitive positions or anything like that. And I think that that is not intentional. And so what I believe the final result of this statute will be is that if you drug test someone and you do it legally, like the only way you can drug test someone now is if you have reasonable suspicion that they're high at work, or they're showing symptoms at work, or they're in a safety sensitive position. If you follow all that rules, even if you follow all those rules, the only way you can discipline this employee, if the only thing that came up positive was THC, the only way you can discipline them is if you have a policy. Okay, so I hope that's clear. I think the main point of this new statute is that it's saying we want employers to have a written policy, and there's going to be limitations on how you can discipline your employees. The way that it's going to be legal for you to discipline employees is to follow a written policy. Okay, so that's kind of like the big takeaway from the whole webinar. All right, so then the last just thing to touch on is that the statute specifically provides that if an employee is aggrieved, in other words, the way an employee could be aggrieved is, let's say you're an employer and you want to drug test an employee because you kind of have this sense that the employee uses marijuana or uses drugs. In this case, let's just say marijuana, because we're talking about this marijuana statute. If they really weren't showing symptoms at work, you just kind of feel like you know they use marijuana, and so you drug tested them, that would be a violation of the statute. And so that employee could bring an action in court within 90 days of the termination. And if it was found that the employer illegally drug tested them or fired them in response to the drug test, the employee could get reinstatement to the job, the wages that they lost, and their attorney's fees. So the statute this last paragraph just makes the point that there won't be a valid lawsuit by the employee if the employer had a good faith belief that the employee used or possessed recreational marijuana at work, or if they had a good faith belief that the employee was unfit for duty. And then there also will not be a cause of action where let's say your employee injured a third party, but the employer had no way of knowing that it turned out the employee was under the influence of drugs. If the employer had no way of knowing that, then the employer won't be able to be sued. Okay, that's just kind of like a stipulation that was added to this statute that takes effect next year. So the things to kind of keep in mind, what are you going to do going forward? First of all, I just want to emphasize, like we did in the beginning of the webinar, remember nothing changes until next year. And so know what the law is now, because that's in effect for still another year. And then the first bullet point here is I recommend that employers remind their employees that although there is this new law in Connecticut that provides that it's legal to have and use marijuana at home, it's still not legal at work. And so don't come to work high or drunk. You have to be able to do your job, and you have to have a clear mind, and you have to be able to use judgment and not be high at work. The second recommendation is that you update your employment policies. And so one thing that I think will be a really common thing that you'll need to fix, I mentioned this earlier, is that your policy, if you have a policy now, it probably says that you forbid the use of illegal drugs. And so you want to remember, well, there's a drug now that's legal. And so you want to just emphasize that at work, employees are not allowed to use any kind of drug that's intoxicating. That will mean that they're under the influence of an intoxicating drug while they're at work. And then the third thing, I guess this would flip the order. Before you make that policy, you have to decide, you have to discuss with management, what do you want your policy to be? You don't have to, like we said earlier, you don't have to drug test people. You don't even have to have a policy that prohibits the use of marijuana at work. I mean, that would really be your rule, but it's important that you know that if you think you have an employee that's shown up to work and they're high, you don't even necessarily have to discipline them. This is another thing that came up just recently. An employer was telling me that he really believed that one of his employees was high at that moment, but that employee's job was to sweep a shop floor. And so remember, it's important not only that they're under the influence, but that they're under the influence in a way that impacts their job. That's the standard that is for testing, right? And so in theory, that employer could definitely fire that employee for being high at work. That's against the rules, or maybe it's not, but let's say that's against the rules. It's important to remember that employers do have some discretion. And I think one of the ideas behind this new law is the idea that employers, unless you're exempt, employers may want to consider to be a little more open-minded maybe, or maybe not as strict when it comes to recreational marijuana. And so those the statute is still emphasizing you cannot be high at work, but keep in mind that people might be using recreational legal marijuana over the weekend. And so you may not want to discipline employees for that. Okay, so that's kind of those are the practices going forward. Luke, do you want to let me know if there are questions?
Hi there. Yes, we do have quite a few questions coming in.
Okay.
Let's start from the beginning. We had a first question that came in actually through email before the webinar. This question says, we just hired someone and her test came back positive. We have only allowed positive results with a doctor's prescription. She said this was a doctor's prescription, and then she said it would take 2 weeks to get the card. 2 weeks have passed and we haven't received anything from her. Now that it's legal in Connecticut, we were wondering what's the best way to handle this situation.
Okay, so I'm assuming, so we're talking about medical marijuana? Is that your?
Yes.
Okay, so first of all, the way that you react to the way that, okay, I got to stop myself there for a second, because the distinction between legal and illegal in Connecticut really isn't going to be the issue here. The issue here is medical marijuana. That's your understanding from the question, right? We're talking about medical marijuana. It's just that she hadn't given her card. Yeah, so I guess what I would do there is I guess the employer is doubting maybe whether the employee is telling the truth. And that's really just going to be a matter of contacting the employee and emphasizing that this is something that the employer really needs. And so the employer can have the rule that you not be under the influence at work, right? And so if the employee is having a positive result simply because they have a medical marijuana card, the effects of marijuana can actually still show up on a test after 30 days. And so you're obviously not going to be high at work. I think the effects of marijuana itself only last 24 hours or less. And so it's important to make that distinction between how long is it showing, how long is it, can it stay in your system and show up on a test versus how long is it actually impacting your behavior. And so in this case, it's not affecting behavior at work. She hasn't even started work. And so if she does have a medical marijuana card, I think that's something that they should just follow up with and see if they can get that card. And if she's not going to provide it, they'll have to decide at that point whether what they want to do with that. But it's just a matter of, I think, following up and emphasizing to her that that's something that they need.
Thank you. I have two kind of related questions. These are about services that fall under the exemption for construction. One would be tree service workers, and the other is landscaping.
Okay. So the first thing that the employer would do is figure out if so they want to know if they're exempt for construction.
Yes.
Tree service worker. And what was the other one?
Landscaping.
Yeah. Let me look. I think that is going to be a matter of contacting the labor department, because thinking about, I don't think that is going to fall under construction. And so you know what though? So I was originally thinking we were talking about safety sensitive positions, but we're not, we're talking about exemptions. And so that's interesting. Forget what I said about contacting the labor department. So those NAICS codes that I mentioned earlier in the seminar, those are actually just at the employer's discretion, whether they fall under, like, let's say construction had a code of 22. That would just be up to the employer to determine if they had that code 22. And so I think that's going to be a matter of, oh man, that is a tricky question. Who do you contact to, you know what, I'm going to go back and I'm going to say, I think that is going to be a labor department issue. And it's not going to be an issue of figuring out if they're safety sensitive. It's going to be an issue of deciding whether this new statute is going to consider those positions to be exempt. And the thing is, there won't be an easy answer to that, because the statute doesn't have anything more specific in it. It just says construction. And so I think it's just going to be a matter of time and having the legislature kind of tweak the statute more and until it's more specific. And it's a good thing it doesn't take effect for another year. But in the meantime, between now and then, I guess what I would say for this employer is to see if the labor department can offer any guidance on that, on whether they think those positions will be considered construction.
Thank you. I have one more question about exemption, and
Yeah.
that is an auto repair shop. Would that be exempt under transportation?
I don't believe so. I believe transportation had to do with delivery services or having people in your vehicle. I don't think it had to do with repairs. But you know what I would do for that? So that has a specific NAICS code, which I don't have right in front of me, but all you have, if you Google transportation, NAICS, that code it'll come up with a code for transportation, and it'll specify what is considered to be transportation. It'll probably indicate whether auto repair is in there.
Thank you.
Yep.
We have an employee operating a company-owned insured vehicle, gets into an accident and injures or kills a pedestrian. The drug test post-accident shows positive levels of THC in the employee. Could the driver be labeled as impaired at the time of the accident due to the positive test, even if they did not consume marijuana that day? And would the company be liable?
All right, so that has to do with the question of whether the company can be liable. That's going to have to do in part with whether the company had any reason to suspect that the guy was under the influence. But remember, we talked about how long marijuana can actually stay in your system versus how long it can impact your conduct. So I don't think that simply the fact of the test being positive, I do not think that that necessarily will mean that that indicates that the employee was under the influence at the time of the accident. I think that if that were to turn into a lawsuit, or if that were to become a dispute involving insurance companies and the like, it may actually come down to actual medical evidence and expert witnesses trying to figure out what the level was, how much the guy weighed, things that are kind of outside my expertise. But it's important to know that simply the fact that it was in his system does not translate to it impairing him, because it can stay in your system for so long.
Thank you. You mentioned if someone tests positive, that you need to retest. If
Yes.
the test was originally a split specimen test, does that satisfy that? Or does it still
No.
need to be an entirely separate test?
No, it has to be an entirely separate test. And I was afraid you were going to ask how much time has to go by, or what's the least amount of time that can go by, because the statute doesn't specify that. The only thing that it says is that if you have one test and it comes back positive, you have to conduct another test, a separate test. So then people say, well, what if that's several days later? That's obviously going to, or maybe impact the results, but that's what the statute says.
Another question about exemption is non-medical home care services for the elderly and disabled considered exempt?
Non-medical. I'd have to go back and look at my list. Hold on one. Yeah, because that's an exempt position, and it's on the slide. So that's step 3. And so that would be care of children, vulnerable people, right? Number 9 of the exempt employees. So it can be a medical patient, or it could just be elderly or children. So those positions will be exempt even if the person you work for is not in an exempt industry.
Thank you. Next question. Under current law, are medical marijuana card holders allowed to be positive in the mining industry, and can we discipline them?
Okay, so whether someone's in the mining industry or not doesn't have anything to do with current law. What mining means that you're exempt from next year's law. So then the only thing you have to figure out is your employee who's working in the mining industry under the influence of marijuana while he's working? And so if he has a medical marijuana card, the employer may be thinking to himself, it seems like there's a chance this guy might be under the influence of marijuana at some point. But you can't, what the law says is you can't just use that you can't presume that the person is high because he has that card. And so the important thing to do is kind of it'll monitor the employee to some extent, I guess. You don't want to harass the employee, but you have to observe the employee, and based on his conduct and his appearance, make a decision about whether he's under the influence. And if he is, even with the card, then that's not permissible.
If you have an employee who tests positive, and if you don't follow the policy, for example, you didn't give them the positive test result, you didn't make them go through drug alcohol classes, does this leave the employer open to a lawsuit?
Yes. So the drug testing, there are a couple of reasons for the drug testing statute. We're talking about current law. So giving an employee a drug test is considered to be, to some extent, an invasion of privacy. And so there are rules about how you do it. So if you drug test someone when you shouldn't have, like let's say you give someone a drug test and they really weren't showing a lot of symptoms, you really had no basis to give that guy a drug test, you could be sued for just giving the drug test. And then also, in addition to that, if you, or let's say, and in your example, they didn't do a second test, so you can be sued for that, for doing that incorrectly. And then in addition, let's say you give a test and you weren't supposed to, and then you terminate the person based on that test that you shouldn't have given, even if it comes up positive. If you shouldn't have given the test in the first place, you terminate the employee, then the employee could sue the employer for wrongful termination.
I have two questions. Looking for a template for how to write a drug policy. One is for an exempt employer, construction. They'd like their policy, what would the policy look like on pre-employment drug testing? And the other is there a document that can be used as a template to use in the revision of their employee handbook?
I don't have a template for that. Unfortunately, that may be, I think it is safest to actually hire an attorney to do that for you, to be honest. I think employment policies can often get employers into some trouble. And having a good handbook and having employment policies that are reliable and that follow the law are important, and that it may be worth hiring either a consultant or an attorney to do that for you. And so that's not something that I have.
Thank you. And we have one last question. Could you quickly again go over what it means to be an exempt employer?
Okay. So the theory behind the new law that goes into effect next year is that it was going to restrict to some extent what employers could do if their employees showed up to work having used otherwise legal marijuana. And so the idea behind this new statute is that, you know, we want you to maybe be less strict with your employees who are using legal marijuana unless you're exempt. And the reason why you'd be exempt is because your employees have risky jobs where it's really important that they not be under the influence of drugs. And so we're not going to be more lax with those people. And so those industries and employees will be exempt from this new law that's asking you to be a little more open-minded. I mean, I'm saying that as shorthand, but hopefully, as you saw from the webinar, like the new law and the old law, they're not that different. But the idea behind the exemption is that if you're exempt, you can be just as strict as you always were with your employees. The fact that marijuana is legal doesn't matter. It's still against the rules. You've got people working for you in safety-sensitive positions, important positions having to do with kids, whatever it may be. So you do not have to pay attention to these new rules next year. And so you might be exempt because you're in construction or because you're a teacher or a driver. If you're an exempt person or an exempt employer, then you don't have to follow these new rules that may have some restrictions on the way employers discipline their employees. That's the theory behind it.
Thank you. And that was our last question.
Okay. Well, thank you very much for having me. It was a pleasure. If any of you are CBIA members, you can see at the bottom of this screen, if you can still see this screen, you can call our hotline anytime. I'm the one that picks up the phone when you call. So if you have legal questions about this, you can give me a call and we'll help you out. Thanks again, though, for having me on the BBB webinar. It was a pleasure.
All right, yeah, thank you, Diane, and thank you everybody for joining us today. We do have Diane's presentation available to download in the handouts tab if you would like to do that prior to leaving the broadcast today. And then also we are going to be posting this on our YouTube channel. So if you want to go back and hear any of those great points Diane made again, you can do that, and we will email out that link to everybody who joined today. So thank you again, Diane. I know it was a tricky topic and you answered a lot of great questions. So
All right.
have a great rest of your day, everybody.
Bye-bye.